Hello, everybody. I'm privileged to be with you today. I'm reaching out to you live from somewhere in my car in Lekki Town. I would have loved to explore the space around for you to see how interesting the environment is, but it's raining at the moment. And yeah, Nigeria is 60 today. I hope you are fascinated. I'm like, woo! We thank God, we thank God, we thank God. And thanks to you guys out there for being a part of our growth and also being a part of the growth of our country as a whole. At Low Accent, one of the things that drives us is to see that Nigeria grows, is to see that businesses are scalable, is to see that corporate governance is put in place for businesses, and in the long run is to see that Nigeria becomes one of the best economies in the world. And today, as we celebrate the country, I want to also, remind you, remind everybody out there that what we do first is an act of sacrifice, first for the building up of our nation before any other thing. And to you guys out there sending in questions to us, asking questions, making your contributions, sending in your thoughts, sharing your thoughts and all. We're grateful to all of you for being a part of our community. It's a privilege what we do every day, and want to say thank you so much. Thank you so very much for being a part of the Law Accents community. So today it's going to be pretty much a straightforward thing. My intention is to consider two questions, and this is where we want to encourage you. Always feel free to get in touch with us. Ask your questions. Your questions gives us direction. Your questions helps us to know what next to do and what exactly is the problem that needs to be addressed. And until you ask that question, we may never know what we need to talk about. So thanks to every one of you. Thanks to you for being a part of what we do at Low Accent. And like I said, today, my intention is to actually answer two critical questions on the subject matter we've been considering for the past 2 weeks: how to handle dismissal or termination of an employee. Today, I'm going to be looking at this from the employer's perspective. So if you're an employer of labor out there, this session is pretty much for you. And if you are yet to be an employer of labor, I want you to know you also need it, because one day you would become an employer of labor, or at least for information purpose, you actually need to be a part of this. So let me read out the first question, and then we come to trying to address that question from the legal perspective. Now, the question goes this way. I run a company of about 5 staff, and I want to lay off somebody. How do I do this in the best way without violating the position of the law? Now, I'm sure that this person, the question is simply, how do I ensure that after I want to dismiss somebody, I want to terminate an appointment, I want to let go of a staff. How do I do this in a way that it will not backfire? How do I do this in a way that the business I'm running will not be opened up to some form of litigation and all of that? Now, as simple or as many as this question seems, the fact is that there are many entrepreneurs that have a similar challenge out there. Some of them open up, some don't open up. And that's why you need a response to this question. How do you build a framework that will reduce the chances of an employee turning back to say, look, I am aggrieved and I'm coming back for the business I worked for? I'm going to give you 3 different things that you need to check on to manage your employees. Let's start. Number one, the first thing you need to understand as an employer of labor is you need to be very interested in the terms of your employment with your employees. What do I mean by this? There are so many people out there that are employers of labor and do not really care to put structure in place to define the relationship between them and their employees. Choose to look at it this way. You want to go out with somebody, you want to have fun, and eventually you want to settle down with the person, say get married and all of that. And you want to do all of these things. There are no laid down understanding about probably so if there are no laid down, understanding about how do you go about this thing, what are the do's and don'ts, what are agreements, do we want to have children right away, do you want to be a career person, or you're going to somebody is going to be staying home as a housewife and all of those things. Now, where you do not establish rules, anything goes. Let me repeat that. Where you do not establish rules, anything goes. And that's what we are trying to avoid, which is why for you, you ask this question, you should ensure that there is a properly defined relationship between the company and the employees. The way you start this is by ensuring that you have some form of agreement. The employees that come into your company's engagement, do they have some form of letter of appointment? Now, there are times when some of these terms of relationship are driven, or let me use the word, are affected or governed as well, by extension, by some laws. So you need to lay your hands on understanding what are the laws that are applicable to my line of business. I'll tell you generally that some of the laws you need to master, we've mentioned in the course of this series. You need to be in tune with the Labor Act as much as possible. The Labor Act helps you to know in the first place what are the default responsibilities, benefits, powers, duties, and all of that in employment relationship. Even though some of those provisions could be subject to contractual provisions. So you need to master it first so that you know what to play around, what you can adjust and where you cannot make adjustments. For instance, there are standard provisions that affect the vulnerable. There are provisions that affect underage. If you are going to be entering into contract with those set of people, you need to understand all of these things because they impact on how you move on from the relationship. This is very crucial for you. So you need to get to have an agreement, have a letter of appointment, and clearly define the relationship in the letter of engagement. If the staff is a staff that is not needed for all the time, you can make it a periodic relationship. Periodic in the sense of, look, you are engaged today for a period of XYZ period, and after that we could renew or we could move on, blah blah blah. There are a whole lot of things you can do to ensure that you are protected from day one. So ensure you check the terms of your engagement. To dismiss or to terminate, I will soon get to that question. Is the second question on the list that was sent in from our community member. What is really the difference, if any, between dismissal and termination? But let's still carry on with this first question. You also, we've been saying that you need to master certain laws. So we talked about the Labor Act. You need to understand the Employees Compensation Act, right? Because it deals with the aftermath of an employee's life within employment. What happens where there is industrial accident? What is really the definition of industrial accident? What are the benefits that you should have in place for an employee? You need to understand something. Majority of the cases that goes to court, the labor court, are cases born out of grievance regarding what entitlement should be. Majority of them, they are born out of that. And what does this tell you? If you handle this right, we are not necessarily saying that you are not going to be taken to court, but we are saying that you will be able to establish a good foundation that your lawyer can build on in defending your case in court. So you need to also master Pension Reform Act. You need to know if it applies to you or not. If you don't know about Pension Reform Act, please check the session that was anchored by my colleague last week. It's going to guide you on understanding pension reforms, understanding how it applies, or whether in the first place it even applies to your business. Very crucial as well, and a whole lot of others. Then if you are within the space where there is let's say there's a union of employees, you need to know, are there union agreements, are there collective agreements? You need to be sure that the collective agreement doesn't say something about the employment which you are not doing. Very crucial as well. And another thing is this, right? It is not all collective agreements that are enforceable. Not all. So you even need to also be sure that the collective agreement is enforceable, because there are laws that applies to what will make a collective agreement to be enforceable. So you must be sure that all of those things are in place and the agreement is enforceable. When you have mastered all of these things, remember we mentioned the terms of agreement, of employment is very crucial. You then need to come inward again. You ask yourself a question. Do we have what is called maybe employees handbook? Now, sometimes employees handbook may not be enforceable. We need to mention that. It depends on whether you have said this is enforceable or not. There could be the company policy book which talks about what your policy is like, maybe as regards employees. All of these things are things that you need to revisit and be sure you're on the right track. Now, you grow to an extent that you would be able to engage an HR personnel that will come in to also help stabilize relationship and all of that. But it is a plus when you understand how all of these things operate within the system, so that the work of the HR will be to supplement, right, the efforts already coming out from your desk, or better still, your work will be to complement their efforts by reason of your being knowledgeable. So let's move to the next question, where we will wrap it up for today. Please, right, before I move to that question, it is crucial that I mention that if you have stated procedures in your agreement or some form of binding agreement between the company and the employee, you should ensure that you follow the procedure through. Now, in some cases where you don't follow the procedure through, right, what happens is that the employee will be entitled to be compensated depending on the decision of the judge in that case. But to play on the safe side, you need to ensure that you understand the procedure you have stated and you follow it through. So, for instance, if you stated, for instance, that in the employment, an employee, before being, in the case of an allegation against an employee, a panel is going to be set up to find out, to inquire on whether or not the employee is at fault about the subject matter and all of that. You should ensure that you follow that through to be on the right path. So, I'll give you an example. There is this very interesting case that happened some years back. They call it Longe versus First Bank of Nigeria. Now, Longe was the former MD of First Bank, and he was alleged to have done certain things contrary to the standard practice of the bank. And after that allegation, right, there was a meeting that was put up and his engagement was terminated. Longe simply went to court, and what he challenged was the fact that there is a law somewhere that states the procedure for the removal of somebody in his office, and that law was not followed. That due process wasn't followed. And the Supreme Court agreed with his position. Now, what is the lesson for you as an employer of labor? The lesson for you as an employer of labor is summarized in everything I've mentioned earlier. Employment is usually governed by a lot of regulations, including contracts signed between parties, and you need to ensure you revisit those contracts to be sure that you are doing the right thing and you are doing it properly. That is the safest form of protection you can give your business. Now to the question, what is the difference between termination and dismissal? So, this question actually came from one of our community members at Law Accent. They needed to let go of an employee, and they weren't sure, should it be a termination or should it be a dismissal? And then they asked that question. So let's get to it. One of the things I tell employees, entrepreneurs, is that when you look at subject matters that are legal, don't look at them from that complicated perspective of this is a legal language and only lawyers understand the language. That is a wrong notion. You should look at them first from the English perspective. So the word termination means to bring to an end. The word termination means to stop. If I tell you, for instance, that, okay, I want to terminate this program, it means I want to stop this program. But the word dismissal, it carries more weight. If we say, can you please dismiss, right? You will find there is the element of force in it. And what does this teach us from the legal parlance? When you say you are terminating an appointment or an employment or an engagement, it means that you are bringing the relationship to an end, full stop. But when you say you want to dismiss an employee, it simply means that there is something, a wrongful act, there is something that has an element or something, how do I put this now? Something that is pretty bad, something that is a stain, something that it's not a goodbye, it's a bad one, and something that is abrupt. So I use the word abrupt because you do not dismiss somebody that you had a relationship with, and the relationship was to last for a period of time. Say, for instance, you engaged Madam Amaka, right, to be an employee, and the understanding from day one is that Madam Amaka is going to be there for five months, and after 5 months, nothing bad happened. The relationship was smooth. Everybody played their role, and you just had this nudge that, okay, you want to do a dismissal. It doesn't work that way. Dismissal presupposes that something has been done contrary to the relationship between parties. But that is not termination. Termination could be voluntary. Termination could be, we are sorry, we don't need your service again. But dismissal presupposes something bad, something wrong, something uncalled for, something against the basis of the relationship has been done by the person to be dismissed. Now I trust you understand the difference between termination and dismissal. So please, what is the basis of all of this explanation? Is to really encourage you that you should so the basis of this explanation is to encourage you, right, out there, when you listen to this video, to be very sure that you do not go on to just affect the career of people that pass through you. If an employee, for instance, says, look, I needed to move on, right, and that's the basis of me saying that I'm sorry. So if an employee says, for instance, that he or she needs to, okay, sorry about that. So we're trying to conclude now. So if an employee says he or she needs to move on, and you felt that the employee shouldn't have moved on at that time, I mean, it shouldn't be a basis for you to now try to steal a show, right? Even though the employee had tendered some form of resignation, and then you then also try to steal a show and then go to do, I mean, maybe you instruct the HR, or you go to your office, draw up a letter of dismissal and all of that. It doesn't worth it. And that's why you have to be very careful in understanding that there's a difference between termination of employment and dismissal in employment relationship. Please, we would still continue to appreciate your questions. They give us direction. They help us to know what we should teach on. They help us to know what you find interesting. And we'll still be very open as well to having your comments and contributions. We are very open to them, and we'll continue to be grateful. Thank you for being a part of the Law Accent community once again. It's a privilege for us to always come out here to try to guide you on issues that relate to legal matters and your business. Once again, thank you. Happy Independence, and do have a wonderful, wonderful, wonderful day. Bye.